Okay, this is file 24-21908-FH. People versus Timothy Lee Redis. We are here today for sentencing in this case, and we are proceeding today by video conference. Mr. Murphy, would you like to place your appearance on the record?
Yes, Your Honor. Thank you. Matthew Murphy, appearing on behalf of Mr. Redis.
And sir, you are Timothy Lee Redis?
Yes, sir.
Mr. Redis, have you had an opportunity to read and review your pre-sentence report?
Yes, sir.
And have you had an opportunity to discuss that report with Mr. Murphy?
Yes, sir, I have.
This is a sentencing in a felony case. As a result of that, you have a right to be present in person in the courtroom for the sentencing hearing. I would only proceed today if you're willing to waive that right and continue by Zoom. Are you willing to do that?
Yes, sir, I am.
Do you wish to explain or challenge the accuracy or relevancy of any information that is in your pre-sentence report?
No, sir.
Mr. Murphy, does the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
No, Your Honor, but there was an inaccuracy I wanted to point out to the court after speaking with Mr. Jones this morning to confirm, where he confirmed that he did recommend 3 years of probation, but the statute we believe requires 5 years. So that would be a correction on the PSI to correct that 3 years recommendation to 5 years recommendation of probation. So I just wanted to place that on the record. And I discussed that with Mr. Redis, and he understands that already, Your Honor.
Okay. All right, the probation officer has calculated the minimum sentencing guidelines to be from 7 to 23 months. Do you agree with that computation of guidelines?
I do, Your Honor.
Is there anything then, Mr. Murphy, that you want to say on behalf of Mr. Redis before the court passes sentence?
Yes, Your Honor. Mr. Redis, in regards to this matter, in speaking with him from the very beginning, he did take responsibility for his own actions. Now, the court, I want the court to make the court aware that in the incident, he was the individual that called the police in this matter. He was aware when he called the police, things were getting out of hand. The other individual involved ended up having in possession of a firearm, and things were getting quickly out of hand. So Mr. Redis, since he's been in the jail, been in custody, he has made use of his time. He has completed programs. He has gotten certificates via the use of the online programs able to do. He hasn't sat there and just wallowed in the jail. He has made use of it because he has accepted responsibility for his own actions. He is trying to cure those actions, make better decisions moving forward. And so I would ask the court to consider, when looking at, again, the situation, we understand, that the sentencing guidelines are 7 to 23. There is a recommendation of 1 year in jail. I would ask the court to consider not doing a 1 year in jail. Again, Mr. Redis has been making use of the time he's been in there. We believe that further incarceration ultimately is not necessary to use judicial resources on it. So I would ask the court to consider maybe deviating below the guidelines and having credit for time served and then release onto the 5 years of probation. Again, those 5 years of probation we believe are appropriate. That he will, again, with the situation being that he understands his own actions, being what he's done being inappropriate, that he's trying to cure that, and he'll make use of his time on probation. Would also ask the court, if the court is not willing to do credit for time served and released, to consider maybe less time than the year, maybe 9 months in jail with credit for time served. Again, just because we don't believe it's necessary to use judicial resources for that in full year. But whatever the court's order is, whatever the court's sentence is, Mr. Redis will accept it. Again, he's accepted responsibility for his own actions, and he'll abide by whatever order the court passes. So again, we'll just ask the court to consider less incarceration time. Thank you.
All right, Mr. Redis, is there anything you'd like to say on your own behalf before the court passes sentence?
I would just like to apologize to the victim and the victim's family and everybody involved. And I'd like to apologize to the court for wasting their time. And I take full responsibility for my actions. And I'm sorry that I acted out of character, and I'm sorry that I wasn't an upstanding citizen. And if given the chance, I can go back to trying to prove myself to be better than that. That's all I can say.
All right, in determining the appropriate sentence in the case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, and what's been said on the record here today. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Redis is 31 years old, has 3 prior felonies and 6 prior misdemeanors. In this case, has been convicted of domestic violence. And the sentencing guidelines are from 7 to 23 months. As we discussed, the period of probation is required to be 5 years. I think based on what I have heard today, it is encouraging that Mr. Redis has made use of his time at the jail. I think that that supports a sentence at the lower end of the guidelines in terms of jail time. And so that's what I'm going to do. So it will be a sentence of the court, Mr. Redis, that you serve a period of probation for 5 years. You must serve 7 months in the Lenawee County Jail. You do have credit for 137 days served. You must abide by the following conditions of your probation. You must have no contact with Tiffany Rochelle, Lucinda Rochelle, and Tim Rochelle, either directly or indirectly. You must not violate any criminal law of any unit of government. You must not leave the state without the consent of the court. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by your field agent. You must not attempt to submit any fraudulent or adulterated samples. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures, and you must present proper identification at the time of testing. You must not use any controlled substance or drug paraphernalia unless prescribed to you by a licensed physician or be with anyone that you know to possess those items. You must not use any object as a weapon. You must not own, use, or have under your control or area of control any type or imitation of a weapon. You must not be in the company of anyone that you know to possess those items. You must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer without need of a warrant if the field agent has reasonable cause to believe that you have items which violate the terms of your probation. We are going to send to you at the jail, Mr. Redis, 3 copies of a notice of right to appellate review and request for appointment of attorney form. When you get those, you need to sign one under the receipt of notice heading and return that to the court. That just indicates that you received your copies of those forms. If you want to appeal your sentence, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that, sir?
Yes, Your Honor.
All right. So you're all set for today. Mr. Redis, you can let the officer with you know that you're done with court.
Okay, may I ask one more question?
Sure.
Mr. Jones, have you heard anything from Wayne County at all by any chance?
I have nothing to do with Wayne County's violation. They'll be made aware that you were sentenced today, and then they'll proceed accordingly.
Okay.
So, but I will say that if you get transported over to Wayne County, that you still need to report or contact me when you eventually get out of jail.
Okay.
All right.
Yep.
Thank you, Mr. Redis. You have a good day, okay?
Thank you.
Thank you, Your Honor. Everyone have a good day.
Thank you, Mr. Murphy. Okay, Ms. Underwood, are you ready to proceed with Ms. Quinones?
Yes, Your Honor. Thank you.
All right, so back on the record in People versus Nicole Michelle Quinones, we have Ms. Underwood and Ms. Quinones back from the breakout session. Ms. Underwood, you want to place your appearance on the record?
Rhonda Underwood for Ms. Quinones this morning, Your Honor. At this time, I would ask the court to enter a not guilty plea for Ms. Quinones. I believe these are Judge Antlone's cases. Is she back next
That-
Wednesday, Your Honor?
That is correct, and she is back on the 11th, so next Wednesday.
Thank you. We would ask the court to schedule this for Judge Angelone on Wednesday. And also, Your Honor, my client was arrested at Share the Warmth, the local homeless shelter where she is staying, which is local. There's no allegations of any new crimes. This is simply a failure to report and an address change. I would ask if the prosecution or if the probation officer and the court would consider a PR bond, and Ms. Quinones will stay at Share the Warmth. Your Honor, she's welcome back there, and she can see Judge Angelone on Wednesday.
Ms. Walsh, do you have any input on that bond request?
I guess if Miss Underwood can verify she's staying there, I thought they were full.
Nicole?
Yes, no, they're not full. I'm in bed number bed number 6. And they said they hold it for me just there last night. Yeah. Yesterday. I think we're frozen.
Okay, so I will enter a not guilty plea for Ms. Quinones, and I will grant a personal recognizance bond at this time. Ms. Quinones, you need to report to Ms. Walsh as many times as she wants between now and next Wednesday. And if you don't report, another bench warrant will be issued and we won't have this discussion next time. Do you understand that?
I understand, Your Honor. Thank you.
Ms. Walsh, do you want Ms. Quinones to report to the probation office when she gets out today?
No, Monday morning at 8, please.
Okay, thank you.
So Monday morning at 8 a.m. All right. Anything else we need to address with the file today or these files today, Ms. Underwood?
No, thank you, Your Honor.
All right, Ms. Quinones, you can let the officer with you know that you're done with court for today.
Okay, thank you. Yeah, I'm finished. Okay.
Okay, Mr. Glazer, I have Ms. Sanford here. Do you need a breakout session with her?
No, I don't, Your Honor.
This is file 24-21832-FH, People versus Christina Marie Sanford. We are here today for sentencing in this case, and we're proceeding today by video conference. First, can I have Mr. Glazer place your appearance on the record?
John Glazier appearing on behalf of Christina Stanford, Your Honor.
And Miss, you are Christina Sanford?
Yes, Your Honor.
Ms. Sanford, have you had an opportunity to read and review your pre-sentence report?
I never got one, but I think Mr. Glazier and I have spoken at my other court hearing.
Yeah, she had a sentencing on the 2nd, Your Honor, just a few days ago.
With Your Honor Morgan.
Okay. So if you want to have a chance to see a copy of that, we can send it over to the jail and have them bring it to you. or I can just proceed without you having a chance to see it if you want to waive your right to see it.
What do you think I should do, Mr. Glazier? I'm not,
We should just proceed with sentencing.
okay.
It's,
take my-
the recommendations are the same as they were yesterday on this one.
Okay, so about probation.
Well, they recommend the same thing they did downstairs, a year in jail, but we're gonna talk with the judge about that in just a few seconds.
Okay, all right, thank you.
Okay, so Ms. Sanford, you have said that you have had an opportunity to discuss the report with Mr. Glazier. Is that correct?
Yes,
Are you satisfied with Mr. Glazier and the advice that he's giving?
yes.
Mr. Glazier, does Ms. Sanford wish to explain or challenge the accuracy or relevancy of anything that's in the pre-sentence report?
No, Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
No, Your Honor.
Okay, this is sentencing in a misdemeanor case, and so there are no sentencing guidelines. So, Mr. Glazier, if there's anything you want to say on behalf of Ms. Sanford, you can do that now.
Yes, Your Honor. I'm reviewing the recommendations, and I guess I don't know if I think in this one they changed their recommendation as they did in district court from probation to a year in jail. I think they did that on this one as well. But I would indicate to the court that down in district court there was the same recommendation, and the judge down there, Todd, Mr. Judge Morgan, on the use, he gave her 12 months in jail. On a domestic violence, he gave her 93 days in jail. And on an assault and battery, he gave her 93 days in jail, but he suspended all that jail time. He put her on 18 months probation, fines and costs. She's got to enter and complete any program that the probation recommends. She can't consume any alcohol. Will have random testing and search and seizure for drugs or alcohol, and no contact with victims in the case. There were contempts of courts because she didn't show up for her sentencing down there as well. She didn't show up here. He dismissed those contempts. We're asking the court if it will consider doing the same for her here. She had, if I look at her criminal history, right, she has a domestic violence back, gosh, I think it was 2015, and doesn't have any other criminal history. That unless she has some out of state, the only access I have to is in-state convictions, but I don't think she has any criminal history other than that. She does have a drug problem. We or somebody, I think it was our office, got her into a program. And Christine, you were in a program and walked away, is that right?
I left 3 days early, a bad mistake.
Okay. I just want so yeah, she was in a program, judge, and walked away early and then didn't appear at her sentencing. She has a drug problem. I mean, and she really, really needs to get some treatment. And Judge Morgan ordered to enter a program. We'd ask if the court would consider doing the same, maybe giving her the year in jail, but suspending it, and then giving her the same terms of probation. I don't know whether she needs to get into a inpatient program or a outpatient program or whatever, but if the circuit court probation officer wants to talk with Emily White in our office, I'm sure they can get her into some kind of program. I know the programs usually people that have relapses, they're pretty, they're pretty open to taking them back. They understand that this is an ongoing problem, that a drug addict will relapse from time to time. So we're asking the court to file that, give her probation, and let's get her into a program, hopefully get her off drugs. And I think that'll improve her life immensely if she'll do it.
All right, Ms. Sanford, is there anything you'd like to say on your own behalf before the court passes sentence?
That I'm sorry I didn't show up for court. I was homeless at the time and I did have a drug problem. I since then have been clean. Before I came to jail, I was clean and I have been clean for since I left the program. So I've been clean since May. I just had a lot of issues. I now have a support system on the outside world, and I also have a lady that is going to give me work. She's been clean since 1991. Her name is Jen. She runs the AA meetings in here, and I also have support from the church, Bethany Assembly, of the clergy that they come in here, and their names are Rita and Dan, and they go for Bethany Assembly. So I have and I also have Catherine Cobb lined up to stay there. I'm going to go to the probation downstairs as soon as hopefully I'm released today and I can get into an outpatient program, but I really need to get back to work, do the outpatient program, continue my AA. I've been doing AA in here and I went to my mental health counselor in here. I'm back on my anxiety medicine and my depression medicine. I've been doing good. I don't feel like I need inpatient anymore. I feel like I need the strict outpatient, and I feel like I am doing great with that. And I do have a good support system now. At the time, I did not have a support system, Your Honor, but I do have a support system now. And I would ask that I just can be tried to do the outside so I can get back to work and do the support system I have on the outside. And then if I feel like I'm going to relapse or get edgy, and my support system doesn't work for me, then I will turn myself in to take myself to rehab. But I don't feel like I need that right at this moment. I've been clean, like I said, since May. I just was homeless and going through a lot of things. And that's not an excuse why I didn't show up, but that had a lot to do with it. But now I do have a support and I do have places to stay and people that are there and willing to help me. And I feel a lot better in my recovery. I'm a recovering addict and alcoholic. I'm not an alcoholic and addict. I'm recovering. Thank you for your time.
Okay, thank you, Ms. Sanford. In determining the appropriate sentence in your case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here today. The criterion reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for law, and the protection of society. I have heard what Mr. Glazier and Ms. Sanford had to say with respect to Ms. Sanford's substance abuse issue and her current status in treatment. And I think as a result of that, I am willing to follow what Judge Morgan has done and give Ms. Sanford an opportunity at probation. Because I think that is, if she's willing to put in the work and do what needs to be done, that is a better long-term solution to the problem than a jail sentence would be at this point. And the court does have the ability to impose the jail sentence if you're not willing to put in that work. So it is going to be sent to the court that you serve a period of probation for 18 months. Your probation is subject to the conditions that you submit to alcohol, substance abuse, psychological or psychiatric evaluation as required by the probation department, and attend any treatment or counseling that's required by the probation department, that you attend 12-step meetings and obtain a sponsor or home group as required by probation, that you not consume any alcoholic beverages of any nature, including medications, that you not use any illegal controlled substances, that you submit to a regular and random blood alcohol or controlled substance testing as directed by the probation officer, that you make your person, vehicle, residence, and all other personality available for search and seizure for the presence of controlled substances or drug paraphernalia or alcoholic beverages, that you seek, obtain, and maintain gainful employment while you're on probation, that you sign any releases required by the probation department, that you not engage in any assaultive behavior, and that you not live in any residence where there is alcohol or controlled substances on the premises.
Thank you, Your Honor.
Your Honor,
As a
very
result-
good. Is there a contempt of court pending? There was one down in district court. I don't know if one got issued.
She pled guilty on the contempt in this file and was sentenced to 60 days, and that happened on October 23rd.
Now, Your
Okay.
Honor, is there any way that I could get time served for that and then get out today so I can start my probation and all my other classes? Because you told me that you would end the time on today if I was sentenced to something else. Because Judge Morgan said as soon as I was gonna be released on yours, I could go right to probation and get all my stuff started. And I'd really like to do that. I feel like I'm just sitting dead time now. I mean, as far as I want to get into my counseling, I want to get into my anger management classes. I'm just trying to get ahead with this and get this all behind me. This has been going on 2 years and that's my fault. And I'm owning to mine and I want to take responsibility, but I've been here 44 days. So I was just wondering if I could get the rest of the time served and get to probation today and get on with my life and get these things started.
All
I would
right,
ask-
so let me first say that there is a court cost of $750, a state cost of $50, and a crime victims fee of $75. With respect to the sentence on the contempt of court, I'm not going to change that at this point. It was entered on October 23rd for 60 days. If you have a good time, we're talking about a matter of days, I think, before you would be released anyway. And so I'm not going to make any change to that at this point.
How would I find out when I would be released? Take to jail?
You can ask, they'll give you your out date.
Yeah, the jail calculates the good time, so they'll know, they can tell you what your release date is.
Okay.
You should
All
be
right,
pretty
so
close.
anything else we need to address today, Mr. Glazer?
No, Your Honor.
Well, I'm sorry, I neglected, there is a probation supervision fee of $30 per month. All right, so Ms. Sanford, you can let the officer that's with you know that you're done with court for today.
Okay, now do I report upstairs or downstairs for my probation?
I think
I
you're
really-
gonna have to both.
No, it's, your probation is all managed out of the district court office with Mr. McCarron.
Okay,
All right.
thank you.
Okay, thank you, you're all set then.
Thank you, Your Honor. That's all I have with you this morning.
Okay, thank you, Mr. Glazer.
All right, we'll see
Ms.
you later.
Underwood, do you need to speak to Mr. Clark?
Yes, thank you, Your Honor.
Let's come to the judge will say first. Could we have Larry Clark in the room for the judge, please? Oh, I'm sorry. How about? Thank you. Bye.
Okay, this is file 24-21804-FH, People versus Larry Dean Clark. We're here today for sentencing on a probation violation, and we're proceeding today by video conference. Ms. Underwood, you want to place your appearance on the record?
Rhonda Underwood for Mr. Clark this morning, Your Honor.
And sir, you're Larry Dean Clark.
Yes, Your Honor.
Mr. Clark, have you had an opportunity to read and review your probation violation recommendation report?
Yes, sir.
And have you had an opportunity to discuss that with Ms. Underwood?
Yes, Your Honor.
Do you wish to explain or challenge the accuracy or relevancy of any of the information that is in the
Your Honor, there are,
report?
I'm sorry. There are a couple, my screen keeps blinking. There are a couple things that first of all, Mr. Clark is incarcerated, I believe, for a new charge from October. And the time served would not be correct, but I'm also wondering if perhaps we might want to wait on a sentencing for that, for this, until we know what Mr. Clark's situation is on the new charges. Mr. Stevenson?
I believe he's on a PR bond right now. As far as pushing back the sentencing, I'd be fine with that.
Okay. So we did, Ms. Underwood, give him a PR bond on this at the time that he pled guilty.
Right. Well, I would hope
And
the court.
Must not have been incarcerated at that point. So
That's
apparently
correct.
arrested after that on new charges. So that would explain the jail credit.
I would hope the court would consider giving him credit for the time that he's been in, Your Honor. But I'm also wondering if we might want to adjourn this until we have an idea of what's going to
the
happen.
recommendation is for 15 days.
Right. I understand that. Okay, then.
And so isn't he likely to be there more than 15 days on his new charges if he's not made
Right.
bond?
Right. All right. Then I guess.
I've not been
I'm not
to jail for
trying
like,
I'm not trying to force anybody into anything, but it would make sense to me to just sentence him to the 15 days and let him serve those and have this cleared out.
Okay. Okay, Your Honor.
Again, I'm not trying to force you into anything. You want to speak to Mr. Clark and.
That's fine, Your Honor. I apologize. The screen keeps blinking and it's extremely, I don't know if it's my connection, but it's very
Let me put you back. Let me put you back in a breakout session with Mr. Clark and you can talk about it.
Okay.
Okay, so Ms. Underwood, do you know how Mr. Clark would like to proceed then?
Yes, we're going to proceed to sentencing today, Your Honor. Mr. Clark is aware that if the probation department chooses, they can bring another violation, Your Honor. Your Honor, Mr. Clark obviously has a substance abuse problem that he's dealing with. Mr. Clark, this violation, I think, Your Honor, is fortunate because now Mr. Clark can address the situation. The recommendation of him keeping the 7411 at this point and 15 days in jail. Your Honor, Mr. Clark went into jail again, I believe, on the 16th or 17th. We would ask the court to consider giving him credit for that time and releasing him on time served, Your Honor. Thank you.
Okay, Mr. Clark, is there anything you want to say on your own behalf before the court passes sentence?
Just to apologize to the court, Your Honor. It's not like I'm actually doing this intentionally. It's like by default, like it just happens this way, and I'm not trying to make no excuse for it, but I just do want to apologize to the court that it has transpired as such with you giving me the opportunity that you have.
All right, I have reviewed the probation violation recommendation report, and again, it's a first technical violation, and so the recommendation is for 15 days in the Lenawee County Jail. It will be the sense of the court that Mr. Clark served 15 days in the Lenawee County Jail with credit for 15 days served. You do have the ability, Mr. Clark, to request an appeal of your sentence. We're going to send to you at the jail 3 copies of a notice of right to appellate review and request for appointment of attorney form. When you get that form, you need to sign 1 copy under the receipt of notice heading and return that to us. That just indicates you got your copies of those forms. If you want to appeal your sentence, you need to fill out the remaining portion of the form and mail that to the address listed in the form within 42 days. Do you understand that?
Yes, Your Honor.
Okay. You are all set with court for today then.
Judge, we won't violate him on the new charges. We'll just bundle this with these charges of violation.
All right. So I don't know if you heard that, but Mr. Stevenson indicated that he would not violate Mr. Clark on the new charges.
Thank you, sir.
And then please report upon your release to probation.
Thank you.
Okay, and probation will be continued, and this was also a sentencing on the contempt of court for the failure to appear at the BOP summons. So sent to the court on the contempt will also be 15 days in Lenawee County Jail with credit for 15 days served.
Thank you, Your Honor.
Thank you. Thank you, Your Honor.
All right, thank you. And Ms. Underwood, you need to speak to Mr. McNett.
Oh, I don't need a breakout, Your Honor.
Oh, I'm sorry.
No, I spoke to Mr. McNett yesterday.
Okay, 1 second. Okay, then this is file 23-21548-FH, People versus Teron Wayne McNett. We are here today for sentencing on a probation violation. In this case,
Could we have Antoine
And
send
we are
us
proceeding
the-
today by video conference. Ms. Underwood, would you place your appearance on the record?
Rondo, you would for Mr. McNett, Your Honor.
And sir, you are Jerron Wayne McNett.
Yes, sir.
Mr. McNett, have you had an opportunity to read and review your probation violation recommendation report?
Yes, sir.
And did you have an opportunity to discuss that with Ms. Underwood?
Yes, sir. Just as of yesterday.
Okay. Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, sir.
Do you wish to explain or challenge the accuracy or relevancy of any of the information that is in that report?
No, sir.
Before the court passes sentence, Ms. Underwood, is there anything you'd like to say on behalf of
Yeah.
Mr. McNett?
Your Honor, thank you. Mr. McNett, Your Honor, I think is employed. He's working. Who are you working for, Mr. McNett?
I work for Carl Huff and DNC Roofing. That's out of Hudson, Michigan.
Okay, and so he does have employment, Your Honor. I'd like to see him get back to that. He's done, Your Honor, he understands that he should have reported. And I think he just was concerned that since he couldn't pay, he was in trouble. He's done a significant jail term now. I think 15 days already. I would ask, I know the recommendation is for 45, Your Honor. I would ask the court to consider releasing Mr. McNett and allowing him to go back to work and get back to paying, Your Honor. I don't see where any more jail time is going to improve this situation. It's just going to further hamper Mr. McNett's attempt or ability to pay this off, Your Honor. So I would hope the court would consider, rather than the 45 days, releasing him with the 15 days served, Your Honor. Thank you.
Mr. McNett, is there anything you'd like to say on your own behalf at this point?
I mean, everything's pretty much been said. I understand I put myself in a kind of a bad situation here, but I had full expectations of myself to turn myself in. The very day before I got arrested, I fully legalized my vehicle, put insurance on it, plates, registration. I've been working. If I get out in another 30 days from now, I'm going to have no insurance. I'm going to have no way to get to work, to get the money, to get insurance. I'm going to be back, not to square one because I didn't have a vehicle before, but I'm going to be set back. Again, I am the one that made the mistake, so I'm not here to argue with anybody. And honestly, it could be a lot worse than 45 days. So that's all I have to say, sir.
All right. It's always a difficult balance in these cases. Obviously, the main objective here is to
If more than $100 a month is asked out of me, it can be done. I can pay more than that. I can pay way more than that if needed.
All right, so the goal when I place someone on probation is to, you know, get them back, get them working, get them in a place where they're not committing any additional offenses. You know, on the one hand, it's hard to do that if you're not reporting. On the other hand, it does sound as though you've made some strides. I have reviewed the report and I see the explanation for why you didn't report. It's obviously not a good reason for not reporting, and what you've done is made things worse for yourself by trying to, you know, hide from the problem or run from the problem rather than dealing with it head on. And so I hope that this would be an experience that you can learn from and, you know, understand that if something happens and you may have to face a tough consequence, that you just deal with it head on rather than dealing with a much more difficult consequence that happens once it all eventually catches up to you. I do think, based on what's been said on the record here today, I think that the appropriate way to go is give Mr. McNett another chance with time served and the understanding that you need to do what you need to do to complete your probation requirements. If you're not doing that, and if you're running from that, you know, the next time you get caught under similar circumstances, I'm going to have a lot less empathy for the situation, because this is the moment at which you need to learn this lesson and take it with you going forward. So it'll be the sense of the court that you serve 15 days in Lenawee County Jail with credit for 15 days served. Ms. Teskey, do you need him to report to you when he's released?
I do, Your Honor. I actually would like him to report to me Tuesday morning at 8 a.m.
Okay, so you need to report on Tuesday at 8 a.m., all right?
Yes, sir.
Good luck, Mr. McNett.
Thank you, ma'am.
All right, there was also a contempt of court. The sentence on the contempt of court is going to be also 15 days with credit for 15 days served.
Yes, sir.
Thank you. Your
Okay,
Honor,
so you're all set. Mr. McNett, you can let the officer with you know you're done with court for today.
Your Honor, aren't there sentencing appeal forms?
Oh, I apologize. Thank you, Ms. Underwood. We're going to send to you at the jail, Mr. McNett, 3 copies of a notice of right to appellate review and request for appointment of attorney form. You need to sign one of those and return it to us. That just indicates you got your copies of those forms. If you wanted to appeal your sentence, you would need to fill out the remaining portion of the form and mail that to the address listed in the form within 42 days. Do you understand that?
Yes, sir.
Okay. Now you're all set.
Thank you, sir.
Thank you.
I believe that concludes my docket, Your Honor.
Yes, we're all set. Thank you, Ms. Underwood.
Thank
Have a
you.
good day, you
nice
guys.
Weekend.
Supposed to be locked shortly.
He is.
Okay.
Logged
I don't
on.
know, just the jail log it.
Yeah. Probation.
There's another file, 23-236. Darren said he didn't. His terms and They're gonna ask you for those. Just in case they do, probation violation. If you don't need it, then we shred it. Okay. It's just, it's the usual rights. Okay. Alright,
This is file 24-22017-FH, People versus Antoine Lamar Simmons. We are here today for arraignment on a bench warrant alleging a contempt for violating bond conditions. We are proceeding today by video conference. Sir, you are Antoine Lamar Simmons?
Yes, sir.
And Mr. Goldstein, you want to place your appearance on the record?
David I. Goldstein appearing on behalf of the defendant.
Okay. Mr. Simmons, have they given you a copy of the warrant in this case?
No, sir.
Can you stick your head out the door and ask them to give you a copy of the bench warrant?
Okay.
Judge, I actually neglected to send that to the jail. I'll send that over to the jail now.
Okay, someone a copy.
Yeah, we haven't received it. We attempted to call for it.
Okay, Mr. Coast is sending that. Mr. Coast is sending that to the jail right now.
Okay,
And
I
so
will
once
bring
that
that
gets there, I appreciate that. So while we're waiting for that to happen, Mr. Simmons, I will let you know that the warrant alleges that you violated your bond conditions by selling cocaine on 2 separate occasions in the city of Adrian on December 5, 2024, according to Detective Bear of the Adrian Police Department.
So I never saw anything. I was catching a ride.
Oh, okay, so Mr. Simmons, I don't want you to say anything right now because I have to let you know what all of your rights are before you say anything so that you don't unintentionally compromise your position. Mr. Goldstein represents you on the underlying case. I assume you want him to represent you on this as well. Is that accurate?
Yes, sir.
Mr. Goldstein, do you want to speak to Mr. Simmons?
Your Honor, at this point, it's a little bit hard for me to talk to him only in the sense that I have no idea what, the only thing I know is I got a phone call from your office this morning telling me that he was on the docket. I haven't seen the warrant, the bench warrant. I haven't seen any police reports. I know nothing about the case, and I know what Mr. Simmons is going to tell me is that he has no idea what this is about. So I don't know what else there is to talk about, Judge. I mean, we need to get this arraignment done so that I can get some discovery and get some reports and prepare his defense.
Okay. So I'll enter a not guilty plea then. I presume I didn't hear you say that, Mr. Goldstein, but I'll assume based on what you said that you want a not guilty plea enter.
Yes, we've known each other for a while, Judge. You understand my language. Yes, thank you.
And so I can set it for this coming Wednesday. That would be December 11th at 8:15. If you want something that quick, or I'd leave it up to you, I guess, as to.
Well, Your Honor, I'm assuming Mr. Costa is going to send me a copy of the warrant, but what I really would like to see, which I'm sure he doesn't have either, is a copy of the police report. If there's an allegation that my client committed crimes, that there should be a report submitted to the prosecutor's office. I'm assuming Mr. Costa doesn't have that. Is that true?
That's true, David. I did talk to the officer. He is preparing a report. He did send me an email basically explaining the allegations. But yeah, I'll be happy to send that email to you.
Okay, I appreciate it. I'd like to get this as quickly as possible, Your Honor. Thank you.
Can I say something?
I
know what to say and what not to say. I just want to.
I defer to Mr. Goldstein. So, Mr. Simmons, you're represented by an attorney, so he speaks for you. If Mr. Goldstein's okay with you saying something, that's okay with me, but I want to compromise his ability to defend it.
Yeah, I don't think at this point, Mr. Simmons needs to say anything more than the fact that he's not guilty of this. We don't need to get into the details at this point.
Like, what about a bond or something? Like, I can't just.
He's going to get to that, Antoine. He's going to get to that.
Like,
Hey,
All right,
Coach,
so-
did you already,
Sorry, she said something.
did you already fax it? Because we haven't gotten anything yet.
I'm faxing it right now.
Okay.
All right, so the bond on the bench warrant I set at $100,000.
Damn. Why that much?
Well, you're scheduled for sentencing on April 3rd of next year for a conviction that is similar to the allegations that resulted in this bench warrant, and also similar to the allegations of the criminal activity in this very file. So that would be the reason for the high bond in this case.
Mr. Simmons,
They
we
took
can
me to the
address it
sheriff's
on
office
Wednesday. We can address this on Wednesday after I get the reports and we find out what they're claiming you did. Because you're telling me you didn't do it. But I have no
They strip
paperwork,
searched me
nothing
and
on it.
everything. You know, like,
All right, Mr. Simmons, you can let the officer with you know that you're done with court for today.
I go to bench warrant thing.
Okay.
So what you want to hold it?
You're just entitled to have a copy, so I just need to make sure that you've gotten a copy.
Okay. Let me make sure.
All right, I have someone here logged in as 1+DE2118. Your device is muted, so I'm going to send you a request to unmute your device. All right, so can you tell me your name, please?
Melissa Guy.
Can you spell that last name for me?
Guy.
And what case are you here for?
For the it's for an estate for James Guy.
Okay, just 1 second, miss. Do you know, are you supposed to be before Judge Solomon?
Nope. Michael Olsaver.
Okay, I don't have anything on our docket for that case.
I have the case number.
What is that?
It's 7466CH.
Judge, there's a motion hearing in that case on January 6th.
Okay. All righty. And that was my mistake. I'm sorry.
Okay, no problem.
Thank you.
Yep, have a nice day.
You too. Thanks.